Welcome to the webinar 2.0 of the 2002 Labor Law webinar series. This Labor Law series has been organized by COTRA as an initiative driven by the Embassy of the Republic of South Korea in association and collaboration with their legal advisor, Suri & Company. My name is Simar Suri and I lead the international law practice at Suri & Company. Suri & Company is a reputed full-service law firm which was established in 1984. It is headquartered in New Delhi, India, and has offices in Chandigarh and Bhubaneswar with affiliated offices and lawyers pan-India. We advise the government and private companies across industries, including but not limited to aviation, banking, ports, finance, real estate, pharmaceuticals, cosmetic products, healthcare, and others. We also advise international businesses on how to do business in India and give them an understanding of labor and employment laws that are in force in India at the moment. A common concern that runs through most of these organizations is the need to understand the ramifications of employment laws. And our corporate legal department deals with advisory services, which include advice on labor laws. And we have significant experience in employee dismissal cases spanning the last 2 or 3 decades, HR policy drafting and compliance. And since our dispute resolution team is also quite strong, we also have extensive experience in dealing with the disputes that come out of employment contracts across judicial hierarchy, which is from the district courts to the Supreme Court of India. In this context, COTRA has informed us of common issues faced by Korean individuals and companies that set up businesses in India. And most of these issues relate to employment laws and termination. So since organizations have to deal with a multitude of HR policy issues and legal violations, they want some advice on what is the correct procedure to follow for employee dismissals as per Indian laws. Therefore, today's topic is the procedure for termination of employees and on account of misconduct. Please note that all of the cases and the analysis that we make in this presentation are for illustrative purposes only. If you have any specific queries, please feel free to get back to us individually and either through Ms. Choi or directly with our email coordinates are given on the last slide of this webinar. Okay. Just to give you a background, labor law is a concurrent subject in the Indian Constitution, which means that central as well as state laws apply to it. When it comes to central laws, there are 2 primary laws which relate to industrial employee-employer relations. One is the Industrial Disputes Act 1947, and the other one is the Industrial Employment Standing Orders Act 1946. In addition to this, Indian trades and businesses are also regulated. Private trade and businesses and professions are also regulated by state-specific Shops and Establishments Act. Now, the Shops and Establishments Act exists in most states. There is some minor variation in the implementation of the rules. Largely, they are similar, but each state has its own. So there is a Maharashtra Shops and Establishments Act, a Delhi, a Rajasthan, so on and so forth. When we talk about the structure of Indian laws, there is no standard process given for termination of employees. An employee may be terminated as per the provisions of their individual contract and in accordance with the policies of the company if it is a private company, and if it is a factory or a mine in some cases, the standing orders that are formulated regulate the conduct of the employee. So in cases there is no legal requirement for an employment contract to be in writing, but it is highly advisable that you have an employment contract in writing to avoid future disputes and litigation. In cases where there is no labor contract or a defined procedure for termination is not given, then the state laws apply for termination, and this becomes a little bit of an ambiguous territory. So we always advise that you give the drafting of such employment contracts to competent employment lawyers, so we can make that contract in harmony with your code of conduct and other HR policies. So in Indian law, there are two types of employees. One is an employee that covers employees in all sorts of roles, which include managerial, supervisory, or administrative roles. The other ones are workmen defined under the Industrial Disputes Act. And these workers do not perform any managerial, supervisory, or administrative role. The precise definition of workmen is given, but the courts have looked at the exact role being performed by workers to be able to determine whether they will be treated as workmen under the Act or non-workmen. And just as employees are of two kinds, employers are also of two kinds. One kind of employer is an establishment which encompasses all sorts of employers. The other one is factories, which is a term that typically refers to manufacturing units, which could also include mines at some point. In addition to this, certain state laws may exclude senior executive management personnel from their scope of application. Then employment contracts take precedence. Therefore, it is extremely important to draft them with a lot of care and keeping all of the different laws in mind to safeguard yourself. In case of contract workers also, typically when you hire contract labor, you must hire them through a principal employer, which is a licensed contractor only. And then that is the source of all your contract labor. This is, contract labor is allowed in certain sectors, and that varies. Now, when we look at the grounds for termination, Indian law recognizes several modes of employment termination. One is the expiry of a fixed term contract. This is when your Indian Contracts Act governs your employment contract. And once it comes to an end, you may decide to mutually separate with the employee. The second is voluntary resignation by an employee. Third is retirement because of age or superannuation. Fourth is a layoff when you're trying to shut down a business vertical, or you're trying to shut down some operations. You may ask an entire part of your firm or a couple of employees that you need to step down from your positions and we need to lay you off. Breach of employment contract. Again, this is governed by the Indian Contracts Act largely, unless it is a factory, which will be determined by the Industrial Disputes Act and standing orders. Willful misconduct comes as a part of your breach of employment contract. Employment contracts lay down the code, read with the code of conduct, lay down the exact parameters within which an employee is meant to function within an organization. And this should be made very clear to them on day one of their employment with the code of conduct and other HR policies, so that they are in absolutely no ambiguity about what is expected from them. When you talk about misconduct. Now, what is willful misconduct? Typically, it comes under the breach of an employment contract, but here we're dealing with it separately so that we can lay out the procedure for you. When you look at the etymology of the term misconduct, mis means bad, and conduct refers to behavior. So it actually means that in any act or conduct of an employee where they are being prejudicial to the interest of the employer, or they are inconsistent or incompatible with the norms of their discharge of their duty, or it is unsafe or undesirable for the employer to retain such an employee in service, or if the employee has had a loss of faith, of confidence in this employee, it amounts to misconduct. Now, this is just an illustrative list. This does not constitute the entire gamut of what constitutes misconduct, and that is looked at from case to case. The laws relating to dismissal and termination are different for employees in the worker and non-worker categories. So this is important if you're looking at dismissing someone who is in a managerial position and someone who is in a worker position. So employees in the worker category are governed by the Industrial Disputes Act and the Industrial Employment Standing Orders Act 1946. For any employees that are non-workers, that is employees in a managerial or supervisory role, they will be governed by the Indian Contracts Act. So their employment contract read with the HR policies and the code of conduct will determine their actions. So for workers, it is mandatory to terminate their services with cause. That is as per the law. The causes for termination include misconduct, continued ill health, non-renewal of contract, redundancy, non-performance, etc. For non-workers, although there is no reason that you can terminate them without reason, but recent court judgments have made it clear that an adequate and reasonable reason needs to be given for non-workers also to for their services to be terminated. Now in India, we do not have employment at will, which means you cannot call your employee and say you are fired, pack up your things and leave this instant. You have to give a reasonable notice period, and a reasonable notice period, or you give them wages in lieu of that notice period. Either one of the two has to be given, and ideally to avoid disputes, you must make sure that a reasonable cause for termination is also specified. Discipline is the backbone of all healthy industrial relations. So the promotion and maintenance of employer discipline is essential for the smooth functioning of any organization. Disciplinary action can also help employees function in a more healthy manner within an organization. Several examples of misconduct can be divided into major and minor misconduct, which means, say you are there is a lack of punctuality, or you're habitually late, or you take a long lunch break. These are minor infractions. However, there are major causes for misconduct, which would include breach of security or breach of confidential information, or extreme insubordination, or conviction for some crime in a court of law, or willful neglect of duties. All of this would require a disciplinary proceeding to be held with the employee in terms of in line with the principles of natural justice. Now, what is natural justice? Natural justice is giving the employee a chance to also present their case forward. This principle comes from English law, and we are a common law country, and we derive most of our legal traditions from English law. And this is called audi alteram partem in Latin, and this means every party has a right to be heard. Therefore, any disciplinary inquiry has to have the employee's perspective put forth as well. So industrial establishments which employ more than 100 employees will have the Industrial Establishment Standing Orders Act applicable to them. Other establishments which employ less than 100 employees are at the discretion of the state government, and they frame their rules, which are called service rules. However, in recent years, the jurisprudence of the courts has developed, and the courts have laid down several principles which indicate the correct procedure to be followed and the basic formalities that the employer has to keep in mind during this process. Certain sections of the Industrial Employment Standing Orders Act lay down the principles of natural justice and have specified them. And most of this, as an overview, look at maintaining a neutral attitude towards the workman until the inquiry has been concluded. The employee in question must be informed about the charges leveled against him with the framing of a charge sheet. That is stage one. Although there is no statute, let's remember that now this process has been developed as a part of judgments and cultural and social norms in several sectors and industries. So the first thing we do is framing of charges. So you have to make an official and specific charge sheet about the charges that you are leveling against the employee. The employee must be given a chance to refute these charges and establish his or her innocence. He must also be given a chance to cross-examine the witnesses in his defense, and evidence at the inquiry should be adduced in his presence. The punishment awarded, if the employee is proven guilty, should be in proportion to the misconduct that you have alleged. So therefore, it is important, one, to be specific in your charge sheet. In the framing of your charge sheet, you have to give specific instances. You breached confidential information to company X, and therefore we are taking this disciplinary proceeding against you. So it would be seen that it is an elementary principle of natural justice that no man or woman should be condemned to a punishment without being given an opportunity to explain their circumstances. Therefore, now there is a procedure. So first you ask the employee to submit their explanation. In the explanation, first, if they refuse to accept the charge sheet, you can send it to their registered address and through registered AD, so that your intention to serve the charge sheet upon the delinquent employee is clear. If the employer apprehends that there is a physical harm of this person being in the premises, they may suspend them. However, please remember that Payment of Wages Act governs the payment of wages of all employees. And until the inquiry is completed, they are still employees. So payment of those wages has to be made. However, you can do it post-inquiry. And the employee is entitled to full wages until their suspension lasts, even if the outcome of that inquiry is dismissal. Then the employer may consider, the committee of the employer that is examining this may consider the reasons given by the employee. The employee may submit may admit to his misconduct and ask for leniency. The employee may refute the charges and submit their explanation with regard to that. They may apply for an extension of time for submitting the explanation, or they may fail to submit the explanation. Now, it is still advisable, even if the employee has admitted to their guilt, you must still conduct a full inquiry, because later the charges that may come to the employer would be that you did not, you forced me, or it was under coercion or something. And here in labor laws in India, there is a very, very big bias towards the workers. So therefore, all the courts are pro workers. Therefore, employers need to be extremely careful when conducting such disciplinary inquiries. And if you're an individual employee, your rights should be made aware. You should be aware of your rights so that you can contest any unfair dismissal. You must also ensure that an unbiased inquiry officer records the finding. Then consideration of the inquiry proceedings and findings by the authorities leads to a decision and the final order of punishment. And then the employee is informed of the punishment that is decided to be awarded to him. But none of this can happen without a show cause notice. So a show cause notice is, please tell us, show us what caused you to do this action. Now, if you are an individual employee and you have been wrongfully terminated, whether you're an international or a domestic worker within the territory of India, you have certain rights, you have certain remedies. It is important for employers to be extremely careful while terminating the services of their employees. Again, labor courts are within their rights to award reinstatement of the employee along with back wages to be paid by the employer. Since there are two categories of employees, workmen and non-workmen, with respect to employees in private organizations, the limited remedy available for wrongful termination is damages to the tune of the salary for the prescribed termination or notice period. And for workers, the remedies include reinstatement and back wages, which will be subject to relevant facts and circumstances. Where the worker is terminated for cause, reinstatement or damages are unlikely to be granted, where the termination is justified by cause and the termination process was fair. So therefore, if you can if you can convince the courts, if it reaches that stage, that your inquiry process was fair, then there is a chance that reinstatement and back wages, if the termination cause is also justified, will be upheld. Now, when we look at common trends, it is important for employers to balance the process with termination of the employee, and be extremely discreet and very be on firm footing when they are terminating an employee, and give them valid reasons supported with evidence that this termination is in fact warranted. So while we look at the rights of the employer, they are also they also have to be extremely mindful of the fact that there may be a backlash, there may be a complaint to the labor courts by the delinquent employee. There may be social media posts against the company, which may harm the company's business. There may be a complaint directly to the parent company overseas or domestically, or a complaint to the police, which again is a procedural and legal issue that companies may want to avoid. Therefore, please be extremely careful when terminating an employee, and please seek legal counsel before you do so. Now, what are the consequences of wrongful termination of employment under law? So when an employee is being terminated on the grounds of gross misconduct, the employer does not have to issue notice and full and final settlement, but it is advisable to do so even in cases of gross misconduct, so that it is not challenged by the employee at a later date. If the employer is found guilty for any wrongful dismissal by a labor court or a tribunal, the employer can be directed to pay the employee and restore the service of the employee, as the case may be, and there may also be a penalty involved for the employer. So therefore, again, please be extremely careful. Therefore, now, what is the way forward? What is it that we must keep in mind before we commence upon this very precarious employee-employer relationship, and how do we manage this? So first and foremost, please ensure that your employment contract is written. It is drafted by a legal counsel. It is in line with your code of conduct and other HR policies, and has all of the terms and conditions that you expect from your employee written down, so that they cannot claim at a later date that we were not aware of this. When you look at the process of conducting an inquiry, the employer must keep in mind that the employee has a right to submit his or her defense if they are accused of misconduct. The employee handbook must have a code of conduct, which should be in line with the employment contract. They read together. So they should ideally be drafted by the same employment lawyers. Employees should formally receive and acknowledge the employee handbook along with their confirmation of employment. And if there is any update, it should be communicated to all the employees formally, and acknowledgements should be taken for this. The code of conduct should definitely lay down a procedure that your organization will follow in cases of disciplinary proceedings, and explain exactly what is not allowed, even if it is the dress code or a policy of not sharing information outside of the confines of the office. So it is important.
Ms. Simar? 양해 말씀드립니다. 잠시 한번 1분 정도. 네.
In the cases of factories, employees.
It's 12 o'clock.
Okay. Am I audible?
Yes.
So therefore, with that, I just wanted to bring this last point and then invite my colleague, Mr. Bhavneet Singh, to talk about 3 illustrations briefly. So he's going to talk about 3 cases where businesses will need to formulate contracts and HR materials, keeping in mind regulatory, social, and cultural idiosyncrasies that are framed in Indian labor laws and court decisions. These illustrations will give you an idea of how to deal with cases of misconduct. Thank you.
Thank you, ma'am. So as Sima Suri has rightly explained the procedure and the position in respect of the termination of an employee in case of misconduct, now I should proceed with the case studies that in respect of the common issues that are experienced by the employer during their course of business. So my first illustration is respect of non-performance by an employee. So this is a company. Company A has around 20 employees. 5 of them are Indian, 5 of them are foreign nationals, and rest of them are locally recruited nationals. So one of the local national is working under a foreign national and he's reporting to the senior. But the senior is of the view that the local national is not working up to the mark and his performance is not appropriate. So in this case,
Excuse me, Mr. Bhavani Bora.
justice, there should be a properly defined.
Mr. Bhavani, could you please repeat again because connection was unstable.
Yeah. So now I'm audible, ma'am?
Yeah.
So ma'am, my first illustration is in respect of non-performance by an employee. So a company A has 20 employees where 5 of them are foreign nationals and the rest of them are local nationals. So a local national who is the sales manager is reporting to a senior who is a foreign national. And a senior national is of the view that the performance of local national is not up to the mark and the conduct is not appropriate. So in these circumstances, what actions can be taken against the employee? So the proposed solution is that in the majority of the countries, non-performance is an accepted ground for termination. In India as well, the non-performance is an accepted ground, but in India, we follow the principles of natural justice. So it is suggested that there should be a properly defined procedure as well as an established practice in case of termination of an employee in case of non-performance. So ideally, it is suggested that there should be the reporting manager should clearly and formally communicate to the employee that what are the shortcomings in his performance and what can be done regarding that. Pursuant to the same, he should be put on a PIP. PIP is a performance improvement plan where he should be given an opportunity to improve his performance. For example, the quality of his work is not good. For example, he is not reporting on time. So he should be given sufficient time, a reasonable time basically, to improve his performance in due course. And even after that, he is not able to improve his performance, then the employer can rightly proceed with the termination. But in these cases too, one of the serious things that should be kept in mind by the employer is the evidence. Evidence like what constitutes poor performance should be recordable by the employer. For example, there should be a proper yardstick of measurement of performance in case the employee is to be terminated on account of non-performance. Because failure to do so may result in employee turning hostile against the company, which may lead to outrage on the social media platform as well as defamation against the company. Now moving to the second illustration. So this is a disciplinary issue. For example, a company is operating a manufacturing facility as well as a corporate office in a single premises. And the company observed during the course of business that 2 to 3 employees are trying to instigate others to create an union and which can be proved to be troublemakers for the management. So in these circumstances, what actions can be taken against the subjected employees? So ideally, disciplinary and the proper code of conduct should be properly defined in the handbook and the policy of the company. So in typically the same issue in the previous illustration, there should be proper evidence and employees should be able to. Can you hear me, ma'am? Hello?
Yes.
Yeah. So while some things are implied by an organization that the employee should report on time, he should not speak loudly, there should not be any physical abuse or verbal abuse against any colleague. But to prove that an employee is a bad influence on others, that can be hard for a company. So in these circumstances, we suggest that there should be proper evidence, and initially a warning should be issued to the employee. And even after that, the employee is not restraining from that action, then the employer can proceed with the termination. But in these cases too, there is one serious concern that should be kept in mind, that is in relation to that the social history and the religion of the employee, that where it comes from. For example, if the employee who is being terminated belongs to a backward class, who is belong to a reserve category or is protected, then he can easily claim victimization against the company, which can result to disastrous consequences. Now, moving on to my last illustration, which is a normal example by breach of confidentiality by an employee. For example, an employee is working in a company, his performance is fine, his results, he is showcasing satisfactory performance, but the company discovers that the employee has spoken in an event organized by its competitor without informing the company. So in this case, what can be done against the employee? While we understand that this is a major issue and holds importance and value for the management, since it questions the integrity of the employee, integrity as well as the loyalty of the employee towards the company. So in this case, what we suggest is that the employee should be first made aware, like what action has been done against him, and he should be issued a show cause notice. And pursuant to the above, the employee should be asked to submit his response in writing. And subsequent to the same, an inquiry should be conducted by an internal committee in the company, and wherein the questions should be formulated in such a way that there is no ambiguity and gaps in the facts of the matter. And even after that, pursuant to the same, if the employee is not able to submit a satisfactory answers against the show cause notice, then the company can proceed with the disciplinary action against the employee, and this may be either suspension or termination. So now I conclude my presentation. So if anyone has any questions regarding the subject matter, may kindly let us know.